I would like to welcome each one of you. I'm so glad to see you. And not just today, but you may come back anytime the doors are open at Mount Vernon. We welcome you. Before we get started, I would like to just make some announcements regarding if you would like, once we start, if you would like to ask a question, please raise your hand so that someone can bring you a microphone. We are on Facebook and YouTube and conference calls, so we want to make sure everybody is heard. Um, if you need to, go to the restroom, out the doors to your left, of the restrooms. We will now, ask if everyone would get a hymn book. You may already know the song, What a Fellowship, and it's on, I believe, page number 262. We will now have prayer by Pastor Javon Jackson, followed with scripture by Sister Edna Johnson.
Hey, will you all pray with me? Bow your head. God, we are so grateful for your goodness, for your mercy. We thank you, God, for allowing us to be present in this place in this moment. We also thank you, God, for the wisdom that will be bestowed upon us, God, as we just deal with life, how life happens and how life goes. Thank you, God, for giving us the resource to be better equipped in such times. So we ask that you would bless this assembly, bless this fellowship, bless this information. In Christ's name, amen.
I shall read from your Hebrews 9th chapter, the 16th through the 20th verse. For where testament is there, must also of necessity be the death of the tester. For a testament is a force after men are dead, otherwise it is of no strength of all while he tester liveth. Whereupon neither the first testament was dedicated without blood. For when Moses had spoken every precept to all the people according to the law, he took the blood of calves and of goats with water and scarlet wool and hyssop, and sprinkled both the book and all the people, saying, This is the blood of the testament which God has enjoined unto us. Moreover, he sprinkled with blood both the testament and all the vessels of the ministry. And also all things are by the law purged with blood, and without shedding of blood is no remission. I have read the 9th chapter of Hebrews from the 16th through the 19th verse. May God add a blessing to the reading of his words for the edification of our soul. Amen.
We're so glad to have our speaker this afternoon or this evening. And I'm going to introduce her to some of you, and there are some here already know her, and she's well known throughout the CSRA. Attorney Cicely D. Stallings, better known as CC, is an attorney at Hull Barrett PC, helping people with real estate, consumer issues. Hull Barrett PC has an office in Augusta, Georgia, serving the local community. Ms. Stallings attended law school and graduated from University of Georgia School of Law in 2007. She began practicing law in 2008. Ms. Stallings was admitted to the Georgia Bar in 2008 and to the South Carolina Bar in 2018. Ms. Stallings has negotiated major agreements representing artists, songwriters, producers, and production companies in the entertainment industry, music, and TV/film, with various companies, distributors, and networks, Universal Records, Atlantic Records, Columbia Records, Warner Chappell, HBO/Time Warner, WeTV, Bravo, LT Entertainment, and Hyde Park Entertainment. She has experience as in-house counseling for a in-house counsel for a boutique music label located in New York City, Manhattan Center, and recently has been handling business formation and corporate contracts, nonprofit formation and organization, commercial and residential real estate, transactions and related matters. Ms. Stallings represents clients in civil court, estate planning, and probate. Ms. Stallings was selected as 2021 Super Lawyers by the Star. So we have a well-equipped person to talk to us about these issues. And I'm sure there will be quite a few questions once you hear what she has to say. So I present to some and I introduce to some Attorney CC Stallings.
So I don't know who she was talking about. Me, I'm just CC, and I'm here to just kind of spread some knowledge for you guys. I don't know, the way I like to do these presentations is more so like a conversation, okay? Everybody's good with a conversation, right? And so it works best if you ask questions, I'll kind of go through some things. I'll ask you some questions, and then you can ask me questions as well. So mainly today, we're talking about estate planning. How many of you actually have an estate plan in place? I know the sheriff. So nobody has a will? Okay, you have a will. I see a couple of hands. 1, 2, 3, 4. Okay. Anybody have a trust? What about even a power of attorney? Okay. Now, do you guys know there's a difference between a power of attorney and a living will, which is also we call it a healthcare derivative or a healthcare power of attorney. You familiar with those? How many of you have one of the healthcare power of attorneys? Couple. Okay. Under what circumstances did you get yours done? Did you just get like a whole package done with an attorney, or?
No, actually, what happened was I ended up having cancer. And so my husband and I both had cancer at the same time. So therefore, it was kind of like, we got to get this done. And that's what made us get it.
Okay, so usually that's when I see, that is usually when I do see people come in when they have, they've been diagnosed with an illness, or they have to have surgery. Surgery is a big thing. Or if a loved one gets sick, because it kind of hits you like, oh my gosh, I am immortal. One day something's gonna happen. And, you all have assets. Everybody in here either has a car or a house. Show of hands of who owns a house. See, that's almost everybody. I see almost everybody owns a house, but there are only about 3 people or 4 people that have a will in place. So, one thing about your house that I want to ask, do you know how you hold title in your house? And when I say hold title, how do you own it? When you got that deed, I don't even know if you paid attention to it. When you got the deed, is there anybody else on title with you? Like if you're married, you have a spouse, right? Your spouse is on title. Did you notice on title that it might have a provision that says, as joint tenants with right to survivorship? Does your title have that, ma'am?
My title just named to my daughter, so,
So you actually transferred to your daughter?
yes,
So your daughter owns your house right now?
yes.
Okay. So some people do that. What made you put the deed in your daughter's name?
She just wanted to make sure that it was taken care of very well, She lives far away, so when she come home, she has somewhere to stay.
Okay. So did you have an attorney do the deed, or?
No, ma'am, I went to the courthouse and did it.
Okay. So I do want to give you guys another option. So there is a way that you can have, your spouse or your adult child, and I do say adult child because when you put minors on title, it causes all sorts of issues when you go to try to sell. You have to get the courts involved with that. But what's your name, ma'am?
Edna Johnson,
Edna, so for Miss Johnson, she could have done a deed with rights of survivorship, a joint tenants deed. Then she could still be on the title and have her daughter on the title. And what would happen is that should anything happen to either one of them, not just her, because young people, they've been passing away too, and it's scary. I'm 42, and I have classmates that are just dropping like flies. It's scary. But what that does is, should one of those people pass away, the property actually goes to the surviving tenant, which would be, if your daughter, heaven forbid, were to pass away, she would be the surviving tenant, and vice versa. Then you would not have to actually do probate to get the property out of the estate. So those are options for you guys. There are different ways you can do it. Some people do what's called like a life estate. A life estate with, I know y'all didn't come from real estate necessarily, but this is part of your estate planning in mind. When you own a house, you need to know the different ways you can hold title. So life estate is, for instance, you'll have the property and you'll hold it for life. And then at the time that you pass away, then that property goes to your surviving or contingent beneficiaries, which are the people that you name and say, once I pass away, I want these people to have my house. And it's just in the deed, it's a deed. So they do have a vested interest already, but it doesn't actually vest 100%. They don't have ownership until you pass away and your life estate has extinguished. So these are just different ways. Did you have a question? These are just different ideas and ways that you guys can protect your assets. Does anyone in here also have like rental properties? You do have rental properties, okay. And so with your rental properties, are they in your personal name or, do you mind sharing?
They're in my personal name.
Okay,
It's in my personal name.
all right. And so with your, with those rental properties, you also want to think, you have assets. And I'm pretty sure you said you have a will, right? Okay, so in your will, I'm pretty sure you take care of all that. So that's another thing. When you have assets, that's why you want to have a will, right? So we want to look at people that are involved with the will. You have one is your testator. Testator is the person who makes the will. That would be you. The other people we have, and I put all of this is in this trusty little sheet. It's a cheat sheet. You guys can always refer to it. Because if you go to an attorney, and even if the attorney is not me, you want to know what you're talking about. You want to know what they're talking about. You don't want somebody to just kind of sit down and be like, okay, well, what do you want? You want this to go to this person and that person, and then they're writing up all these documents and you don't know what you're talking about. That's what we do, right? Okay. So you can always keep this cheat sheet. It's the basics. There are some questions, just kind of common questions on the back of this. Like, do you need a lawyer to write a will? Well, a lawyer is not required to draft and write your will. There are, I'm sure you've seen on the internet, there are, you can go to like Rocket Lawyer, and there's a one for wills and stuff like that, and you can type in some information, and it'll spit out just kind of a generic will for you. So one thing you want to make sure is those things are not state law specific. So if you live in Georgia or you live in South Carolina, you're going to get the same will as somebody that lives in California. They don't really make them state specific. So if there are specific laws for a type of conveyance or a type of bequest that you're doing, it wouldn't necessarily be covered because, well, one, you wouldn't necessarily know to cover it. I mean, you can research. I think all of you are capable of researching, but lawyers, you pay us to do your research. That's what we do. I always tell everybody, lawyers, we get paid to do other people's homework. Because y'all don't want to do homework, you got other things to do, right? So you pay us to do it because we typically either we already know it or we have paralegals and assistants to research it. But in that, it is a good idea to go to a lawyer, especially if you have, like she has investment properties, she has her house, she has her car. I'm pretty sure you have other assets too. Like you've got jewelry, you've got certain things that you want to leave to certain people, or that you want to be handled a certain way. With that, if you have IRAs, well, you generally, things like IRAs, insurance policies, those you should already have beneficiaries listed. Now, we'll tell you this, it is important when you have those accounts, the retirement accounts, the IRAs, the 401ks, all that stuff, the insurance accounts, you gotta make sure that you keep those updated with the beneficiaries. Because if one of your beneficiaries, if your beneficiaries pass away, you'll have generally a main beneficiary, and then you'll have what they call a contingent beneficiary. That contingent beneficiary is someone that takes in the event that your primary beneficiary is no longer with us. Now, if both of them, the primary and the contingent beneficiary is no longer with us, well then, do we know what happens? What happens with that policy? It goes into your estate, exactly. It goes into your estate. So, if you have those insurance policies and then you have beneficiaries who are no longer with us, it's in your estate. If you don't have a will, then you now have what we call an intestate estate. And is anyone familiar with that term? So an intestate estate is basically when you die without a will, which means that your loved ones, in order to do anything with your estate, are going to have to file a petition for letters of administration. And that essentially means that I'm petitioning, or your loved one is petitioning to be appointed as the administrator of your estate, but they're going to go by the law as far as the law dictates who gets what. So if, for instance, you have a spouse in Georgia, we'll just stick with Georgia because that's where we're at right now. In Georgia, if you pass away with no will, everything is split equally between your spouse and your children. So if you, yes, ma'am.
Even if your children are the beneficiaries, named beneficiaries.
This is only, so as in an estate,
Okay.
yes, for the administration, for an intestate estate, your children, your living heirs, which are your spouse and lineal descendants, and then, it goes further beyond that, but those are your heirs. So anything in your estate, if you don't have a will, then yes, your children will be entitled to, a part of that. Now, if your children are the beneficiaries of your insurance policy or your retirement policy, and they're still alive, they will take that outside of probate. That's why the point I was gonna get to with that is you wanna make sure that you are reviewing at least on an annual or even biannual, at least every couple of years, reviewing with your insurance agent or reviewing with your HR, whoever you talk to for your 401k, review and make sure that those beneficiaries are still with us, okay? Because you know who you want to get one. So you want to make sure that it happens. Because once you leave this beautiful earth, you can no longer dictate what happens to yourself, okay? So back to, with the administration, so say, for instance, you don't have any children. You don't have a spouse. So then who's gonna get your estate, right? The way that the state of Georgia looks at it is, we then look at your parents. Are your parents still alive? If your parents are still alive, your parents are gonna be your heirs. If your parents are not alive, it's gonna go to your siblings. If your siblings are not alive, then it's gonna go to your siblings' children, so your nieces and nephews, and it just kind of keeps trickling down like that. Okay? And so that's why I say if you own assets like a house, investment properties, anything like that, you need to have a will. Because, if you leave it to the state, I do a lot of real estate law, and I clean up a lot of dirty title. So those are like heirs property and stuff like that. And the majority of my time dealing with heir property is trying to track down people that live in New York or California that don't know, oh, no, that's my great-great aunt, or that's my cousin 20th removed. I didn't even know that they were dead. Oh, or alive, right, or alive. I never met them.
So I have a question.
Mhm.
Suppose, is there such thing as common law?
No.
Okay.
In Georgia, they abolished that in 1994.
I wanted to ask that because my question is two-part. So if you had a common law person, they say common law, and you have your children, so it would be split just the children, right?
Just the
The other person
children.
doesn't have anything, okay.
They do not. And that's interesting that you asked that because I actually just dealt with, I also do guardian ad litem work for the probate court in Richmond County. And I just was dealing with an estate where the petitioner was the common law wife of the decedent, and actually of the deceased brother before the decedent. And so she had filed and claimed rights to both of those estates. And then the decedent for this petition had adult children. And she was just like, oh, no, I did everything. I was with this man for 32 years. And I was like, I'm sorry, ma'am, but you should have made him put a ring on it.
That's what I see. There you
So
go.
it's like, I was just like, I don't know what to tell you, but, he has children. And they may not be from you. I was like, hey, his wife is actually still alive and they're still married. So I don't know what to tell you.
Yeah.
I was like, I have not seen a divorce decree or anything. So I'm so sorry that you spent 32 years with this man, but you are not entitled to anything in his estate. Because common law marriage is, Georgia abolished that, it's no more. So this is important.
It is.
It's important. If you have somebody and you want to inherit, then you better put it in a will or something, will or trust. Most people, trust has become a buzzword lately, and I did also put together like a trust Q&A for you guys, just so you can read through it. There are different types of trusts. You can even create a trust in your will. That's called a testamentary trust, where it just basically says, hey, when I pass away, I do want so-and-so to have X, Y, and Z, but I want it to be held in trust for a number of years. So if you have minor children that you want to leave something to, you can leave it to a trustee on behalf of those minor children. In Georgia, we do have what's called a minors trust. So it's under the Georgia Minors Trust Act. And so, you can open up an account with a bank, and then you can designate your will for money to go into that minor's account, that minor's trust account. And then there's a trustee that you'll name to make sure that they manage that and take care of the child until they reach the age where they can take the money out themselves.
If the child is a minor, can the parents of that child mess with that money or that trust?
No, ma'am. Not unless if you name them as the trustee. So whomever you name as the trustee, that trustee has the authority to manage the funds in that trust account. Now, they cannot be wasteful. There are rules. So they have a trustee has what's called a fiduciary duty. And the fiduciary duty just says, hey, I promise that I'm going to carry out my duties and do what's in the best interest of the beneficiaries of this trust. And if they do not, they can be sued for a breach of fiduciary duty. So there's, kind of checks and balances on what they do.
And if when you raise your hand, if you could just wait till Mike gets so the people in the back can hear the question.
And I may be getting a little bit ahead, but my question has to do with, since dementia is so prevalent now, how do we protect what we have, should we have to go into, say, a personal care home? Because I just had a friend of mine, she was a neighbor, and she ended up having to go in a personal care home, and they had to strip and sell everything down, and they went back, I think, 5 years and looked at.
So
the
she
history
must have
of-
applied for Medicaid.
She did, because,
Yes,
yeah.
because
She
Medicaid.
was, now, her husband was military, and they were retired, but still, they had to sell a house and all that. So it just,
So that kind of has some extra layers to it, because when you apply for Medicaid, especially nursing home Medicaid, there are certain requirements or restrictions on the amount of money that you can actually have and still be qualified for Medicaid. So that your friend ran into that, they had to sell off everything so that she could meet certain requirements for the Medicaid. I'm actually dealing with a situation with a board on that now as well. And it is, there are different things. I found out through experience that you can put up to $11,000 in what's called a burial account. So somebody that has like nursing home Medicaid, you can put up to $11,000 in a burial account, and that will not be counted towards as part of your income or your assets. So they won't count that in the Medicaid calculations when they're determining if you qualify. So there are different, there's different things you can do. The other option is, if you wanted to say, you can convey your property to your spouse, Oh, you're so, oh, I'm so sorry.
both of them, that's why I said both of them.
Oh, I'm sorry. Do you have children?
I have children.
Okay. So, I'm just gonna go out on a limb and think that you have a retirement account, so you probably are not gonna have the Medicaid issue. But, if you end up in a nursing home and it needs to be paid for and you're not dealing with the Medicaid issue, you can always have a trust account.
Well, that's what I was trying to figure out, if I needed to do a trust. Because I know when my husband died, we ended up going through probate, and that's quite expensive in terms of that whole cycle, and doing it that way. And then recently, my mom, who had dementia, we were trying to figure out something for her. And I know that there is something out there, military allow you to stay in your home and, you know, get care there, but, you know.
Yeah, but I mean, if you don't have those benefits where, you know, you
Yeah.
have that third party paying for it in your
Yeah, and that's
care.
one of the reasons why I'm putting it out there, because I just know with dementia right now being so prevalent and we're dealing with
And
that.
it's getting worse, I see it more and more every day. And, you know, that is something that, you know, you wanna think about, because people are actually getting dementia and Alzheimer's earlier than before. You know, I've seen 50 and 60-year-olds getting dementia now. And the thing is, once you are diagnosed with a memory issue like that, you are not able to legally sign a will, a trust, a power of attorney, nothing, because it's not gonna be legally viable, because you have to be in a sound mind and know what you're signing. And it can be easily contested, so that's why while you are in your sound mind, you're in good mind and spirit, you need to go ahead and just kind of get your plan in place. And so, you know, one thing I always tell people, have someone you trust that you can have as your agent in the power of attorney. Because when you do, if you do get dementia, that person that is your agent under the power of attorney, they'll be able to still manage your affairs for you as if you were doing it yourself. So it doesn't need to be somebody that you trust. Most people have a spouse. A lot of people will have their, you know, a kid, their child. But it, you know, sometimes that causes a little, if you have multiple children, sometimes the kids are like, well, why you picked her instead of me? Just talk to your kids. You can have multiple, if you want, you can have multiple people be your agents. You can have co-agents. I've had a mom do 3 of her kids as co-agents. That just means that each one of them, they all got to get together and make a decision together as to what to do. None of them can do anything for their mom without the other. So just things to think about. I mean, if you talk to your kids, I've found that if you want to do a power of attorney, like financial power of attorney versus a healthcare power of attorney, and you wanted to be one of your kids, most people say, oh, I've got one kid that is the responsible kid. Everybody's got one of those, right? Or if you have one like me, it's like, yeah, I guess, you know, hopefully she'll be responsible enough. She's 9 now, so, and she's pretty mature, but, you know, she loves her mommy now. I hope we survive teenage years and she still loves me. But, you know, I've found that when people, I always tell people, if you're gonna have your children be your agent or be involved, like even as the executor or something of your will, include them in the conversation. And no, you may not want them to know all your assets and everything, but at least include them to the point to say, hey, I'm going to the attorney. I'm gonna talk to them and get some information about doing a power of attorney. I would like you to be my agent. And you need to know what that entails. Would you like to come to the appointment with me, or would you like for me to schedule you an appointment to talk with the attorney? Because it is important that they know. Because some people get scared like, oh, am I gonna have a whole lot of responsibility? What am I supposed to do? Right? The other thing that comes up sometimes when you have dementia, you become incompetent or incapacitated. People will file for guardianship or conservatorship. That has been happening a lot lately. When you do your healthcare power of attorney or your financial power of attorney, you can actually put a provision in one of those documents to say, hey, if a court ever determines that I need a guardian or a conservator, I would recommend, or I prefer this person to be my guardian, appointed as my guardian or conservator. Believe it or not, that helps a lot when the judge is looking at, petitions and if it ever gets contested. I have about 6 cases right now for guardianships and conservatorship where I represent the proposed ward, and the kids are really just going at it because they, the parent is like, well, on one instance, there's one lady who I think she doesn't need a guardian, but her daughter has petitions. She says, oh, she's easily influenced and she's having some memory issues. She's 86 years old, and I should be her guardian. But this lady had just gone a couple of months ago, and updated her will. And that child was not the one named as the executrix in the will. Right. So then it becomes, okay, so what do I do from here? So the other daughter, who was named as the executor in the will, is like, well, I'm named as executor in the will, and I'm named as her power of attorney. So I have a valid power of attorney. I should be able to do what I need, on behalf of my mother, and I don't think my mother needs a guardianship. So now they're fighting. So I always say it's important to talk to your kids. Communication is key. Because as you get older in life, you don't want to have to deal with your kids fighting and fussing over who can take care of mom best and why mom picked this person, why mom picked that person, and didn't pick that other one. Because you may think, oh, it's not that big of a deal, but it is a big deal. It's a big deal to your kids, and when you're going to have to live with them bickering about it, you're just going to be so over it. Just like, geez, I wish I would go ahead and kick the bucket now, But, it just, communication is key. And as part of your estate planning, I would say always talk to your family, kind of let them know what's going on. Other instances I run into, people have wills, and nobody knows where the original is.
Right.
Yeah. Make sure you keep your documents. When you do get your documents done, keep them in a place that at least somebody knows where they're at. If you have a safe with all your important documents, somebody needs to have the combination to the safe. Or you need to have kept it someplace where somebody can find it. Because what's going to happen is if they go to file probate, we can't probate an original will. We have no idea what you wanted, and now we're back trying to do an intestate estate because nobody has a will. Now, one thing I do for all of my clients, primarily the ones that want it or agree to do it, I always recommend that when you get your will done, it's executed, you have copies, we actually record the original with the court, at the courthouse. So then what happens? Okay, you pass away and your child or the person who you named as the executor goes to file a petition to probate your will. And you're like, okay, well, we don't know where the original is. Courthouse is like, we got it. So we got the original. It's all there. This is what you wanted. That's what you said you wanted. It's recorded. You're safe. Now the only downside to that is if you do a will and you record it, but then you update it, you're gonna have to record the updated will too. Because if you don't, then the will that's on record that they know is your actual will, they're gonna be fighting to say, no, this is her last one. This is the one that she wanted. She revoked that one. But we know that the court is gonna say, well, we have a recorded will, and we know that's valid. We know that's original. We know she signed that. We know it was witnessed and notarized. Okay? So that's why I always say, just stay on top of everything. Review these documents.
So now that will, is it public? Can anybody go in and look at it at the courthouse?
So that's a good question. Technically it is, but they do not release it to the public unless it's, unless you have if you go through probate, then of course it's recorded as part of, for example, if you sell a house and they record all of the probate documents and those are on record. But generally the wills, they get kept in a location. They don't necessarily get put up. Like on the online service. So somebody could go to the clerk. I've even had situations where I go to the clerk and just like, hey, do you have this person's will? And they're like, well, why do you need it? Well, they passed away and they said they passed away and their kids said there might be a will on file. Then they're like, oh, okay, if they pass away, we can tell you, yes, there is one or no, there's not. And sometimes they'll just tell you yes or no. But if they pass away and I prove to them I'm the attorney handling the estate, they'll send me a copy. Yes, ma'am.
I like to get right down to the nitty gritty.
Okay.
What are your fees? And do you have a talk with a person on what they might need to bring with them when they come to see you? Like, do they need to bring their deed? Do they need to bring all their 402Bs, 402 case, whatever.
So generally, I do have a consultation with people. I don't charge for a consultation.
No charge.
I do personally an intake session. We can do that on the phone or we can do it in person. I don't charge for the intake sessions. Now, when I start asking questions, say, hey, you know, what do you have? What's your assets? We will go through a worksheet that I've put together. And we have questions and it'll say, okay, 401k, do you have that? If you do, we need the account numbers. And we'll have you write it on the worksheet. So you don't have to bring all of it in with you. Essentially, you'll be working on the worksheet and get everything together.
So send a worksheet to
I can
us
send the
so we
worksheet
can
to
have
you.
all
Yes.
that stuff, you know, because I don't have all that stuff in my brain.
Yes, it's a worksheet. But if you have email, some people don't do email. So if you don't do email, I can just be like, hey, if you want, I can mail you a hard copy of the worksheet. And then that way, we can go through it on the phone. I can answer questions that you don't know, or we can go through it in person, and then give you time to go through and get all that information together. I don't need the actual documents. I just need to know account numbers, the name of the account, and where it's located.
Okay, so what is the fee for that? Are you doing an hourly fee or is it a fee like the power of attorney is so much, the will is so much?
Yes. So we do, we do have packages. So we do an estate package which includes the will, power of attorney, and healthcare power of attorney. If it is a simple will, and when I say simple will, that means essentially from you to X, everything. That's a simple will. We charge for that whole package $750.
$750.
And that includes the recording fees to record the will and the power of attorney if you want the power of attorney recorded.
Okay, does that include the living will or is that?
Yes, so that includes the living will as well.
Okay, so
So that's the healthcare power of
is
attorney.
in this package, oh, I'm sorry, in this package, does it have, what all you might need or how much it all might cost?
So what do you mean?
You
You mean in this that I gave you?
yes,
Oh, no, there's not, I didn't put a breakdown in there.
okay.
This is just, because this is really just for information purposes. But I can provide that to Ms. Brogan if you want, because we do have a fee sheet if you would like that.
Okay, she has it here or?
No, I'll have to email it to her and then she'll print it and get it to you.
Okay, okay, cause, I just went through this with my mother and, there was 5 of us. And when I came back to, see her, which was really the last time she was not, you know, she was still going in and out of dementia, but she was good, you know, when I came. And she changed her will to who was gonna be, the person who was going to take care of stuff, which she did the right thing. But as the person who, the executor, I still had a lot of problems with the other kids, the siblings, you know, so, you know, I want to make sure that, I got everything that I need, I got who's gonna do this, who's gonna be my medical, my this and that and the other, like she had, you know, I wanted, and I only have one child, people, but I'm gonna tell you, when no siblings come in the way, she was my sister before she was your mom. Okay, so I just want everything straight, you don't have nothing to quarrel, you know, you can't quarrel about anything, I just want it all straight. So I can come in and over the phone or come in or whatever you want and have a consultation with you.
So yes, we could have a consultation. If you have an email, I can email you, or my paralegal and I will email you the worksheet. And then we will have a conversation to talk about it. We will then take the information you provide us. We'll draft your will, your power of attorney, and your healthcare power of attorney.
Yes.
and then we will email that to you to review it. And then,
I don't do email.
oh, you don't have email, okay, well then I can bring you in and sit with you to review it.
Okay.
If everything is fine and how you want it to be, at that time, we will then execute all 3 documents.
So you'll tell me upfront, okay, if we execute these 3, it's gonna cost you this much?
Yes, ma'am.
Okay, okay.
You'll know before you get there. I am somebody, I don't like hourly fees because I feel like, when I became a lawyer, I worked under, a lawyer who was just like, look, the hourly fee thing really is just a way for people to gouge, clients. And I don't think that's fair. So, I don't charge for phone calls, I don't charge for emails. Those are really litigator things. I find that for my practice, they're better, because at least with that, what I've done is through my years of experience in doing these documents, I know about how long it's gonna take me to do this, right? I know about, hey, this is probably gonna take me 3 hours to do. So I can put together a package and say, it's gonna cost, $500, or it's gonna cost $750. That's all you need to bring. We can do a down payment, or, half of it, or a third of it, and then you can make payments if you need to make payments. Or you can pay the whole thing. Some people do that. I tend to work with people with as far as their finances, because I understand these documents are important. It's important for your life. I have lots of clients, so it's not gonna hurt me if you're paying, $100 this month and $100 next month, or $100 the month after that to get to your full, full bill, to pay it off.
Okay.
But you'll know, when you leave that day from that consultation, you'll know exactly how much it's gonna cost.
Okay.
Sir, in the back, you had your hand up.
Yeah. Excuse me. If my wife and I come in there together, is it one separate fee or is 2 different fees?
So we will generally come up with a package for both of you together. It won't be $750 and $750, because you're coming together. And a lot of times spouses are like mirror wills, so really it's just changing your name on the second document. So I don't feel right charging you a whole $750 for that.
Okay,
I'm just saying,
thank you.
just excessive.
My question is, 4 siblings, one of the siblings does not want to sign the petition form for the will. What would be the next step?
Okay, so you have the petition, and it's signed by everybody but one.
Exactly.
Submit the petition, pay the filing fees, and then that person that won't sign is gonna get served by the marshal. So, and you can tell that sibling to say, hey, you can you can get an attorney if you want, and you can file an objection, or you can sign it, but either way, if you don't sign this document, the court is gonna serve you because you gotta get service. You're gonna get served by marshal, so.
Well, we do have an attorney, but the attorney is advising the significant other that we will have to put everything in everybody's name and then sell the property. I personally disagree, because if I'm paying you as the lawyer, because the will that they have in place left me as the executor. So I executed everything to the point of, and got it cleared, and now we have that one person, now it is 3 years later, is not signing that document. So it's
So
frustrating.
if he's not signing a deed, or he's not signing for the petition of the will, the purpose of the will?
Yep, the petition, it was a petition form that we all had to sign.
Yeah, it's a
because there was no-
petition for letters.
Stated that there was no will in place, but there was a will in place. But we all signed it except for one. So the lawyer is advising otherwise to sell the property. We don't want to do that. Neither 3 of the others. want
Okay,
to sell the property.
Is it a real estate attorney you're dealing with?
I'm not sure.
Okay, because do you have a transaction on the table to sell the property?
No.
Okay, because what I'm thinking what that attorney is trying to do is, if you guys don't want to go through probate, there are ways to get around necessarily going to probate. Y'all at home, don't say nothing. Don't call me out. But, there are affidavits, if they live in the state, if the property's in the state of Georgia, if the decedent or the owner of the house died 3 or more years ago, you can do an affidavit and get quitclaim deeds from all of the heirs, and then you don't have to probate. You sell it that way.
Okay, that
But-
was my next step.
So that's probably what that attorney is trying to do, because they've been passed away more than 3 years. Okay, I personally think that sibling that's not signing the petition is not gonna sign your quitclaim deed either. I don't think they're gonna sign anything. So that's why I was saying what I typically will do, when I have a probate like that, I will just let the court serve them. They will have their 30-day time period to file an answer or an objection. If they do not, then the judge is going to appoint you as the executor and you call it a day.
Okay, follow the affidavit.
So you're gonna go ahead, and file your petition, because I don't think they're gonna sign the quitclaim deed. With the affidavit, you have to have the quitclaim deed from all the heirs in order for it to be a legal transfer. So if you've already got the petition filled out, you signed it, your other siblings have signed it except for that one sibling, go ahead and file that petition, get it into the court, get it filed, and then the court will worry about serving that sibling. And they can come and make their case to the judge on the day of the hearing. Don't worry about it, let the court deal with it.
I don't think it's coming, because probably been home 4 times out of the whole 40 years that it's been gone. So, all right.
He's just trying to make
Make it hard.
Yeah. So go ahead and file your petition, and then the courts will handle it from there, okay? Saw somebody else with their hand up? Okay. All right, well, if you guys don't have any other questions, anybody have any other questions?
I have one.
Where'd that come from? Okay.
When a person, for the conservatorship, when a person that has dementia, but the doctor won't give you the access to do everything, when, they still, and the doctor says he's in his right mind, but long term, they do have dementia. What do you do about that? How do you go around it? Because you try to get a power of attorney, and most of the time you have to get a doctor to sign off on a power of attorney.
Well, power of attorney, you can get a power of attorney, but the attorney that drafts the power of attorney is going to do an assessment of the person signing, the principal that's signing the power of attorney. And if for instance, you brought that person to me, and I'm asking them questions like, well, what day is it? And he says, oh, I don't know. Or he says, oh, it's Monday, and it's in fact Friday. And I say, well, what year is it? Oh, it's 1950. And I start asking questions, well, what's your name? Well, they call me Jimmy. Well, what's your last name? They call me Jimmy. There are ways you start asking questions. Well, who is this sitting with you? I don't know. You ask questions, and the attorney's gonna do an assessment, their own assessment. And if they feel like this person does not have the capacity or is not mentally there and have enough sound mind, the attorney is not going to let them sign it. And in that instance, what you would do is you would have to file for conservatorship. You could file for guardianship and conservatorship. And even if you don't have a doctor's note, it generally is better having the doctor say that they are incompetent or they have dementia. But if you can get 2 people to sign off, so you as a petitioner and one other person as a petitioner, to say, hey, we believe this person does not have the mental capacity to make decisions for their well-being, their safety, make financial decisions to manage their care. Then the court will actually appoint somebody like me as a guardian ad litem or the attorney for the proposed ward. They will also have a licensed clinical social worker go out and do an interview with the petitioners and with the proposed ward. And that licensed clinical social worker will make an assessment based off of that interview. And they'll file that report with the judge. as the attorney for the proposed board, I also interviewed the proposed board as well as yourself as a petitioner and anybody else that you listed in the petition as someone that might have information or be a friend to this individual. And then I will submit my report and recommendation to the judge as well. And then the judge will take all of that into account and either say, yes, this person needs a guardian conservator, or no, they do not. So you don't have to have the doctor's note. The doctor's note helps. If you just want to have a doctor's note because you can't get a second person to go on the petition with you, then go get a second opinion. I think it was,
So,
Yes, ma'am.
I'm gonna have to make an appointment to see you.
Okay.
seriously, Because how do you, well, we have two executors on the estate. One of the executors got a lawyer to clear her name, I'm sure that's what it was. The other executive is supposed to be helping, they're supposed to be prepared over our estate. But we found out that the first executive has gone in, removed a large amount of money from the estate, but a small amount. So we need to know how to get her, or both of them need to be removed, so we get those.
You're gonna have to file a petition with the court to have the executors removed, because that's what I was talking about, that fiduciary duty.
Yeah.
And that they could be sued for breach of fiduciary duty.
Yeah.
So you're gonna file a petition to remove or replace the executor for them mismanaging and breaching their fiduciary duty.
Okay, so we'll set up appointments with
Yes,
you. We
ma'am.
have to do this soon.
Yeah, I'm surprised that the court didn't require a bond. If it's a large estate with a lot of money, generally the court's gonna require a bond and statements and filing annual reports. But they didn't.
Several of the properties have been sold and the money has been taken out of the estate. You know, we had quite a bit.
Yeah, you need to. Yes, sir.
My question was, you started out speaking about burial monies.
Mhm.
And is that a part of the will, or if you have burial monies, or you won't burial?
So that's not a part of the will. You could, well, once people need the will, then you're generally passed away. So, in the will, it typically states, like, I want you to pay for my burial first. That usually is a provision in the will. I want you to pay for my burial in the manner that I want to be buried, or, have my body disposed of, whether you want to be cremated or put in a field or garden or something. Not legal in Georgia, by the way. But, you can designate that in your will. But when I was talking about the burial account was specifically in regards to the individual who was sent to the nursing home and has Medicaid, and they had a large amount of money coming to them. Because that was gonna basically kick them out of being eligible for Medicaid. And so the nursing homes have this, you can, do a burial account and deposit up to like $11,000 for that individual, and that will not be counted towards your income, for Medicaid.
So is that burial money in the will itself, or?
So generally that burial money is not in the will, but it's in the burial account, so they know that money is to be used.
Who will know?
The nursing home, one, because usually you have an account with a nursing home, or there's a third party. Because generally there's a third party, like a company or a bank, that you have this designated account with. There are companies out there that have that manage these burial accounts, so that in the event that you pass away, that money will be used for your burial.
Thank
So we just called you for appointment.
Yes. This young lady over here has a question.
What is a durable power of attorney? Does that include a durable power of attorney? Does that include financial
Yes.
and healthcare?
That- So durable power of attorney includes everything except for the healthcare. So you still have that living will or that healthcare power of attorney, but the durable means like, it's really just another way of saying your power of attorney over everything. It's a general power of attorney and it endures pretty much until you revoke it.
And I want to ask also, is there any type of will that does not have to be prorated, simple type of will? that
So
does not?
in the state of Georgia, you have to probate a will in order to because somebody has to be given the authority to administrate your estate and to get everything out of your estate. So if you have a will, it has to be probated technically. I'm gonna tell y'all something else. But if you have property, sometimes if it's been a long enough time and you have a copy of the will and you specifically bequest in the will, you say, hey, my property at 1242 Washington Road, I want to leave that specifically to Ms. Brogan or Ms. Brogan, then if she were to go and try to sell the property, the closing attorney could look at that will and use it as what we call a muniment of title, saying, hey, we're gonna do an affidavit of titles, an affidavit saying, this person owned this property, they passed away on this date, they left this will, the will is attached, the will says this person is supposed to get the property, it's a specific bequest, then that person could sell the property. It's just called a muniment of title. That's only something, it doesn't work in South Carolina, but it does in Georgia. But that generally is after a certain amount of time, like years.
But you don't have to record your will. but
You don't
do
have to.
probate.
You don't have to record it, but if there's anything in your estate, then yeah, you need to probate. Especially if your family members are trying to do something with your estate and it's been, less than a year or 2 years since you passed away, they're gonna need to probate it. But Georgia is not fun, I hate to be like this, and all the attorneys are gonna hate me, but Georgia is so easy to probate in. You don't always need an attorney. The forms are online, you can go to the courthouse, and if you just cannot afford an attorney, you can get the forms and you can fill them out. It's not rocket science. You can figure out what to put where and how to put all this information together, pay the filing fee, and take it from there. Now, is it good to have an attorney? Yes, especially in a situation that family is dealing with a sibling who doesn't want to sign, who wants to make things difficult and is likely going to file an objection.
Okay, but if you develop a trust, can you not put your property in the trust
Yes.
and avoid probate?
So yes, you can.
Okay,
Okay, so on trust, you can deed the property to the trust. I see you back there, ma'am. You can deed the property to your trust. And what happens is the trust then owns your property, okay? And the trustee can manage that trust. The beneficiaries get the benefit of whatever income or whatever is generated from that asset, that house that you put into that trust. Does it need to be probated? No, it doesn't, because the trust is an ever-living thing until it's revoked, okay? And so with that, do you still need a will if you have a trust? I always say yes, because there's gonna be something that you acquired since you did that trust that you may forget to put into the trust. You have to actually put assets into the trust for them to be owned by the trust and to be able to avoid probate.
okay, so how long we had this instance in my family where my grandmother died and the will didn't come out until maybe 10 years later. And now it's a mess.
Yeah, it's a mess.
Yeah,
But there was property involved, wasn't there?
yes.
Yeah, I deal with issues all the time.
Oh,
There's But with that, so they do say, and in Georgia, you do have, as the executor, you do have a duty to actually promptly handle the estate. So 10 years, I can tell you what's gonna happen. 10 years, you go file probate for that, the judge is gonna be like, well, why did you wait so long?
well, the person that was supposed to be over it was holding on to it. But he wasn't the executive. So it's.
And if he showed up in court that day when they got it, oh. Because I've had the judge fuss at people when we go to a hearing and he's like, yeah, this person died like 20 years ago, why are you just probating now? I'm like, well, she needs to sell property and he's got 50% interest in the property, so we have to probate. Yeah. Ma'am in the yellow shirt in the back, she had her hand up. You ma'am, you had a question?
Okay, you were saying something early on, and then you said, but you can't do that in the state of Georgia. And you were talking about the garden
Oh,
and else.
sorry, that's my,
I did not get your attention
Mhm.
so that you would not lose your train of thought.
Yes, ma'am. I was just saying, you can decide, you can determine and have preferences of how you want to be buried. And I just made a quick quip about, oh yeah, if you want to be put in a garden or something like that. But you can't do that in Georgia. Georgia doesn't allow you to just, be buried in a garden.
Who's gonna tell?
Well, I certainly won't tell. Seriously. I mean, that's a good question.
Yeah, if I want to be sprinkled around my pear tree or my muscadines. I mean,
So, are you talking about putting your actual body in the ground, or are you talking about? Oh, for ashes. Ashes is fine. Ashes are fine. But like, but like
my
your actual physical
body
body.
was gonna be in my garden.
Because the thing is, what I was getting at
I'll
from
kill
is
a
that in like places like California, they have these burial gardens where, and it's something I had considered. And so I looked into it. So I was like, oh, we can bury you in a garden and grow some trees and flowers and give life, right? And then I was researching and I was like, yeah, that's what I want to do with my dad. And it's like, nope, in Georgia you can't do that.
Yeah, my OBGYN doctor buried his child in his backyard.
Yeah, he
And
had
I
to get
was
permits
living
to
in
do that.
California, at the time.
So
So, yeah, that's
in
allowed.
California, you can do that.
But who's gonna tell about my sprinkle?
I don't know. Somebody's probably gonna snitch though, I'm sure. Snitches get stitches.
Okay, and my other question that I did not, get a chance to ask. You were talking about the children being left as beneficiaries.
Mhm.
Okay. What if I don't want my children, but I want my niece?
You can, in your will, you can put your niece in there. It does not have to be your children. You can leave your property, you can leave your assets to anybody that you want to.
Okay.
You
Now-
can leave it to the church if you want to.
No, they haven't done. Anyway, but does this have to do with various states? Because another state will be involved.
So, okay, so do
I can
you,
read.
you have assets in a different state?
Yes.
Okay, so dealing with property in other states, what's gonna happen? They would probate in the state of Georgia, probate your Georgia will. They'll take that probate document, the order, giving letters testamentary. They will then have to do an ancillary probate in that other state. But your will that you made here would still be put into effect. Okay? So if you say you want your niece to have that property over there, they will take your will, they will take the probate, the order from this court, and they'll do an ancillary with those documents saying, hey, we already probate this, but here you go, we're probating it, we want this to apply in this state. So they will take it and do an ancillary probate in that state.
Okay, thank you.
You know, she was saying about, you didn't want anybody to, inherit certain things. I know when I was doing mine with full board, it specifically asked, is there anybody you do not want?
Yes, you can disinherit people if you want. So if you, I see that all the time. So I had a couple, about a year ago. This was their second marriage. And the gentleman's children, he was like, I don't want them to get anything. I want it to all to be left to my wife's child. And so he disinherited his biological children from the will. That's what he wanted. Yeah. See?
Well, that's about the same question I was gonna ask. Can they contest it?
Yes, you can contest, somebody can contest your will. They'll contest it, that's what I was saying, this young lady's brother or, sibling, he could file an objection, to the probate. And then he has to make his case as to why he thinks that that will is not valid.
But if, say for instance, you leave them, say, beneficiary to an insurance policy, they can't contest that.
No, you cannot. The insurance policy, the beneficiary is who it is.
Oh.
That they're gonna cut, as soon as you die and the death certificate is given, they cut the check to that person. Yes, ma'am, that you've had your hand up for a minute.
Good evening. I just had a question. What kind of pitfalls might happen to a single child if the parent dies and there's no will and that type of stuff?
Oh, well, if that child is the only child, and there's no, and even and the mother or the father is not married, that child is gonna inherit everything.
So is it necessary for them to have a will? Is it necessary for there to be a will in place?
In that case, I mean, you could just let it go by administration, but she would still have to file, she would still have to file a petition for letters of administration, because somebody still has to be appointed as the administrator of your estate. They have to have the authority to actually get stuff out of your estate. It could be her, it could be, your mom or your dad, they could be the administrator and give everything to your child. I have a client now, her grandmother and her aunt are petitioning to be the administrators of her father's estate because her father was not married when he passed away and she's the only child and she's 18. So I actually recommended that she not be the administrator of the estate because it's felt too much for somebody that young.
Thank you.
I think I saw a hand up somewhere else. Okay. All right, well,
Well,
oh,
you
got
had
one
one,
more?
brother?
I did. Now, when you said, the child that got left off the will can contest it, what if the parent meant to leave them off the will, can they still contest it? Do they normally have a fighting chance, I want to say?
So, I mean, typically, as long as the will was validly executed and there's no evidence of duress or anything like that, I mean, they will go through basically a whole trial. And they would have to present evidence to show why they think that will is not valid. And then, they'll have to put forth their best foot. And they have to be very convincing. Because I typically see in those cases, the judge just is like, the will is there. If you can't prove to me sufficiently enough that it's, that there was duress or something else that caused them to sign this will and disinherit you, I'm just gonna go what's on the will.
Who writes that in court? The executive writes for it?
So at that point, there's not an executor yet. At that point, there's fighting to see if the will's gonna be deemed valid by the judge, because the judge has to determine that the will is valid and enforceable. And then, if the person who's, then they'll appoint the executor based off of if that will is valid or not. Yes, ma'am.
So let's say that the will was did in 1986. And no amendments to that will whatsoever, and it was not notarized, but it was sealed in envelope.
Yeah. As long as it was validly executed, that will's gonna be, that will can be enforced. And I would actually suggest, when I have those wills, because the laws changed a little bit since the 80s, it's changed, where they have different requirements as far as the execution of the will and the witnessing of the will. You would have the witnesses, you would wanna see if you can find the witnesses that are signed on that will and see if you can get interrogatories to the will done. Just them saying, yes, this was me, and yes, this was the person that signed, this was the testator, and yes, that was their signature.
Can you tell us anything about air property?
I can give you y'all don't have enough time to talk about air property. But yes, long story short, air property, if you don't take care of it before it gets too bad, it's just gonna never be able to be sold. Because what's gonna end up happening, for instance, I do quiet title actions, and I end up with some properties that have 30, 40 acres. And for the attorney, we have to try to locate all these people, see if they're able to be located, see if we can get deeds from all these people, see if we can get them served. It just ends up being a lot. So I would say if you have property that's still in the name of your grandparent, but you're able to identify all of, your grandparents' children, which would be your mom's, either your mom and her siblings or your dad and their siblings, and then any of them that pass away, if you can identify, your cousins and your siblings, go ahead and get them all together and say, guys, let's go ahead and take care of this. Because the further you go along, the more people are gonna die. It's gonna continue branching until you have hundreds of people. And then it's just, nobody's gonna do it. It's gonna end up where nobody pays the property taxes, and that property's gonna get sold at tax sale.
Okay, but what if you got one person paying the property tax?
So that's when, that one person, they could do a quiet title action, and then they could do a partition action as part of it. So, whatever they're paying for, they could try to get named as, the owner of the property. Says, are they living there, or they're literally just paying property taxes?
The living there.
So if they're living there, they're using the property. Only things in Georgia, you can't own property, you can't be adverse to co-tenants, which the other people would be co-tenants. So, you would have to use legal theories, legal precedents to try and establish that you are the legal owner to that property. You'll have to file a legal action to get that cleared up.
I have a question. Yes. There was a house next door where my property, my house, and I think it caught on fire sometime about 4 o'clock in the morning. Sometime I didn't know it. My neighbor and my cousin told me, it was a fire there. And it's been almost a year now, almost a year. The chairs and everything is still around the house. And it just makes the property
Look bad.
just look bad. And I don't know who to get in contact with.
Okay, you need to call.
311 and everybody else. Because
Did you call code enforcement?
Say that
Did
again.
you call code enforcement?
I know.
You need to call code enforcement at the county, and they'll come out, you make a complaint, they'll come out
I
and they'll,
complained, I called 311 and I reported it to them, and they said that they came and put out a condemned sign on the house. That's been about a year, going on 2 years now,
So-
and all the repairs and all the junk, and I don't even wanna go in my house because it looks so bad.
so what's gonna happen if it's been condemned? Then after, a certain amount of time, they're gonna come and they're just gonna bulldoze it. So, you can keep calling and keep making complaints,
Yes.
but if it's already been condemned, just know it does take them time, because this court process they go
Yeah.
through to get a condemnation order, so they're gonna end up coming through and just bulldozing it.
I don't know whether the gentleman had anybody left in the family or what, I just don't know anything about it. But I keep calling.
Yeah, unfortunately, with that situation, not much else you can do on it.
Thank you.
I do have a couple questions I was sent in. First is, are there any advantages of having a trust for real estate?
Depends on how much real estate you have. So, some people, especially investors right now, they are loving the trust for the real estate. But, and what's your goal? Because if your goal is, like taking advantage of tax shells or something like that, usually, I am not a CPA, and I don't do taxes, but I do know that generally, unless you have a fairly large estate, you're not gonna have any tax benefit from putting it in a trust.
So is there a way somebody can leave the house without those recipients paying taxes?
No. They have to pay, you're talking about property taxes?
Any tax, I don't know what they got, any tax I guess.
Well, property taxes gotta be paid.
Yeah, property tax gotta be paid. I'm guessing
But they're talking about like
inheritance tax, inheritance tax.
So if the property is in a trust, there's not gonna be an inheritance. Because it's in a trust, the trust owns it.
Cool.
And I just wanna put in a plug, the young lady who said something about her church. I don't know if she remember Mount Vernon, but if Mount Vernon, y'all wanna leave a little something, leave a little something.
Why no, Miss Burgess is like giving me the, you know, she started coming to stand and pull me off, because, but I do appreciate you guys, having me here and let me talk to you tonight. If y'all have more questions, you got my card, call me, you know, you can always call me, ask questions, it's nothing to me to answer a few questions for you, okay? But thank you guys very much.
She was great. Let's give her another hand. Someone, dropped that phone by the car. If anybody just-
Is that, you have a couple of cards?
Okay, there are a couple of other, events that I would like to just mention, and that is, the Save the Day, and that is September 18th. We're gonna have a presenter, Dr. Calvin Jackson will be presenting regarding prostate cancer and men's health in general. And you know, we always talk about how women have different symptoms regarding heart attack, and you always want the men to know about it if you have your husband or significant other, whatever. So this time, we're gonna be talking about men, and the women need to be here to know what to look for with them. And then on the 26th of October, we're gonna have like a fall fest, and a lot of stuff for the children activities, the blood mobile, health fair type, vendors. So, to save that date, and that's gonna be from 4 to 7. And the, Dr. Jackson will be here on the 18th of September at the same time today, 6 o'clock. And I wanna thank everyone so much for being here, and, come back again, at any time. We begin service at 10:45 every Sunday morning, and you're welcome to attend. Attorney Styles, will you come, please? We can't pay you for that information, because if we came and sat down to talk to you, I know it would be, to get something done. Everyone give you enough to buy lunch or take you that time. Thank you so much.
On the cards that we passed out, my number is on there as well. So if you didn't get one of the white cards, it's on here if you want to call me. Thank you, guys.
Okay, and this, event was sponsored by our healthcare ministry here at the church. And we have someone on duty every Sunday for any event that we have. And if there's anybody that's Mount Vernon that would like to join the healthcare ministry, come see me. We need more workers. Thank you. We will now have, remarks and the benediction by our pastor, Jackson.
All right, I'll stand right here. Let's give our presenter another hand. And let's give Trustee Rose and this healthcare ministry another hand. Very, not only good information, but necessary information to share with Mount Vernon. Pastoring almost 20 years now. This breaks families. What happens when somebody passes? And so we can upload our information up front. We have a better chance of saving the family reunions, amen? Everybody want to get together, so I am so grateful. No problem relenting this Bible study time, because this is ministering to the whole person. And that's one of our goals, our visions here in Mount Vernon. So we're grateful for it. Thank you so much for your information. Thank you so much for just sharing with us on today. We are going to have a word of prayer, and then we are going to be dismissed from this place. God, we thank you so much for how you put people in our paths that can help us deal with life. Bless each of us. We bless the information we received tonight. And then God, let us continue to be beacons of light, sharing the knowledge that we gain that might help somebody else. God, when we go home, let us find peace there. Let us find your joy. When we wake up, let us experience your brand new mercy. We thank you, God. We walk in your grace. In Christ's name, amen. God bless you. Y'all have a wonderful night. Be safe. Be safe.
Thank you. You're doing wonderful.